Welcome to the Napa Legal Podcast. I'm Frank DeVito, Senior Counsel and Director of Content at Napa Legal.
I'm Kyle Nazareth, the Marketing Content Manager at Napa Legal.
Thanks for joining us for another episode of the Napa Legal Podcast. As always, if you enjoy the content we're putting out, we appreciate it. If you like the podcast, subscribe to our channel on YouTube, Spotify, wherever you're listening from. If you want to support our work, like and subscribe. And also you can check out what we're doing, support us financially, and stay in touch with Napa Legal and all of our works at www.napalegalinstitute.org. So let's jump in. This week we're covering first a recent law in Texas where the school board for the state is adding scripture to its school curricula in K through 12. Then we'll go to the Massachusetts Supreme Court's unfortunate decision regarding the statues of police and fire patrons, St. Michael and St. Florian, that were the city police and fire were trying to install on public grounds. And then we'll end with a Ninth Circuit decision regarding a Wiccan prisoner who had his articles confiscated. There's like an altar cloth and some kind of a stone or something. So we'll get to that at the end. But let's start in Texas. I think this is it's a really interesting law. It's kind of a natural outgrowth of what Texas has been doing. And we picked up this story from a friend of Napa Legal, Andrea Picciotti-Bayer, who's one of the most prolific writers on religion cases in America, in this country. She wrote a piece last week at the National Catholic Register about an update to Texas's public school curriculum, and that's where we are now. So the reading list for Texas's kindergarten through 12th grade will now include, alongside its classic literature, selections from scripture. That's the heart of this law and the controversy around it. Students will be reading, right, not just Shakespeare, but Jonah and David and Goliath in the early grades. Later on, they'll be reading Job, the Sermon on the Mount, mostly taken from the King James Version of the Bible. I will argue in just a couple minutes that this is quite in line with not only the Establishment Clause, but the tradition of the first public schools, who read heavily from the King James Version of the Bible. And this really shouldn't be anything controversial, but in our day and age, of course it is. So this move follows, right, Texas's Ten Commandments law, requiring that the Ten Commandments be displayed in every public school classroom. That was also in the past year, which was upheld, as we've discussed previously, by the Fifth Circuit in the Nathan versus Alamo Heights case. So, as Andrea notes in her article, together these two laws make Texas the state probably farthest along in welcoming back the presence of religious texts and religious monuments in public education. So what is going on here? Why is this a controversy? Well, opponents of the law are complaining that the assignment of these texts, first of all, should be problematic in light of Mahmoud v. Taylor, which I think is really an interesting argument, but it's problematic for at least a couple of reasons. So I'd note first, if you remember, and I'm sure most of you listening to this do, Mahmoud did not actually forbid the Montgomery County schools from assigning these LGBT storybooks being read to elementary school kids, right? The crux of that holding was that the court said that to do so without parental notice and the ability to opt out in that case violated the parents' religious and parental rights. So simply putting religious texts or any texts into a curriculum is not problematic under Mahmoud. That's just not what Mahmoud was talking about. But further, the issue the court had, and they go into a lot of depth in this in the Mahmoud case, is that the texts that were at issue there were normative, right? They were not simply the objective teaching of a text or a topic. The texts were very clearly normalizing certain LGBT behaviors, attempting to discourage beliefs that opposed those lifestyles, right? So they weren't just, here's an issue, here's a text, we're going to talk about it. They were very much trying to form the students one way about that issue. So back to the Texas law, simply teaching the Bible or teaching other religious texts is not the same as teaching children catechism, right? As making a certain doctrine or point of view normative. That's pretty clear, I think, even from the jurisprudence on these types of issues involving the Bible in schools. There was a case that struck down a certain way of teaching the Bible in schools. It was about 60 years ago, called Abington School District versus Schempp. And what Andrea Picciotti-Bayer notes about this case, so what the state can borrow here in Texas is the Supreme Court's 1963 decision in Abington School District that struck down devotional Bible readings as unconstitutional worship in the classroom. But she notes that the court went out of its way in this case to note that the Bible remains worthy of study for its literary and historic qualities. And she says, this is a line that has quietly supported comparative religion and Bible as literature courses in public universities for decades. That's the ground Texas is testing at the K through 12 level, and the case for it does not require any theological premise, end quote. So I think those are good points, right? This is not something that Texas is saying, no, we're teaching Christianity in a positive note, and parents are not allowed to opt out or have notice of these lessons. So this really is not in line with the Mahmoud facts at all. And I would personally go further and say that the Bible, I think, can constitutionally be taught as more than a historical text with some secular and historical value. I think, of course, it would be an establishment clause issue if, you bring a Catholic priest or a Methodist minister to a public school to teach a very denominationally motivated Bible study in a public school, right? Saying that here's the Bible, it supports Catholic teaching, and you should believe it because X, Y, Z, or you should be sola scriptura because of this passage here. Then you're getting into denominationally motivated teaching. But merely teaching Christian principles from the Bible, even in a non-secular light, I don't think you have to be purely secular and historical. That's not an establishment clause problem as I see it. In fact, this is precisely what the first public schools, which were explicitly Protestant, non-denominational, but explicitly Protestant in their teaching, right? They weren't just teaching Bible as secular history. This is exactly what the first public schools were doing. The history on this is pretty clear. The early public schools were a Protestant reaction to Catholic parochial schools, to basically indoctrinate children in Protestantism writ large. They prayed the Our Father in class. They read the King James Bible as a religious, not merely a historical text. So I'm not saying public schools today ought to do this. There are probably prudential reasons I'll get to in a second that maybe they shouldn't, but I think they certainly can as a constitutional matter. So I think to hedge and very quietly say, hey, as long as this is a literary, historical, secular teaching of the Bible, then we're okay. I think that's certainly true, but I think you can go farther and still be within constitutional limits as long as it's not sectarian, right? Denominational. And then finally, I would be remiss if I don't bang this drum. We hit again a question of neutral proceduralism versus substantive goods when we're talking about the comparison of the facts in Mahmoud versus the curriculum here in Texas. Of course, I understand that there are establishment clause limits to teaching religion in a school, even if I think we're not even close to those constitutional limits here in Texas. And there are also prudential reasons, as I said, in a secular culture to be careful here. I don't know that we have a culture that is particularly receptive to public school teaching of Christianity. I don't know that we have teachers who are actually equipped to teach this stuff well in public schools. So maybe it's not a good idea to teach religion in public schools in any form. But the reality is teaching the Bible and teaching Christian texts is a good. Teaching LGBT propaganda to young children is bad. So again, we've encountered this on the podcast before when discussing, laws that ban transgender interventions on one hand and laws that ban so-called conversion therapy on the other. They're different. And I think that's the point I just want to make sure we don't get too far away from. Of course, we're discussing legal and constitutional principles, but I don't want to forget that constitutional arguments aside, we should keep in mind that not all ideas are the same or equally good. Some are good, some are bad. Even if a free society does require tolerating a certain amount of bad ideas for the sake of liberty and for avoiding government tyranny, which is legitimate, we should still be careful not to speak as if all ideas are equal, right? Obviously, there's the issues to cover, but teaching the Bible versus teaching the Satanic Bible, not the same. Encouraging kids to embrace their real and God-given sex and identity is good. Teaching them that boys can be girls is bad. These ideas are just not all equal, and we should not forget those substantive debates about what ideas are good and what are bad. And I think it's a mistake to just focus on neutral proceduralism and ask, well, what does the Constitution allow? So yeah, of course we have to ask that question, but we should also be asking in the public discourse if we are in fact using policy to encourage ideas that are good versus ideas that are evil. So I'll be interested to see, especially as the Texas, Nathan v. Alamo and some of the other 10 Commandments cases go forward, how this Bible as school curriculum case goes forward. This is very early on. They just passed the law, but already you can kind of see the sides lining up. And my guess is that we'll get flurry of litigation like we did with the Ten Commandments law in Texas.
Yeah, I agree with you, Frank, and just wanted to touch on that last point that you're talking about there are good ideas and bad ideas, and that also applies to education as well, right? I mean, what is the purpose of education? It's to orient the mind towards the truth, to form us in habits and virtues that lead us to truth. It's not necessarily just a free marketplace of ideas where anything goes, and especially when children are affected, who are very vulnerable, very open to suggestion, right? In the classroom, every single curricula, all education has some kind of substantive idea of truth behind it, right? It's just really a question of what we want to choose. And it has been the history in this country that education has been largely based on a Christian moral worldview, especially because Western society in general has a civilization. Our civilization is based on a background of Christian morality, right? And to say, oh, you can't teach about the Bible or Bible stories in schools is like saying, okay, in Europe, you can't teach about the history of the Catholic Church or go through Magna Carta or things like this that have extreme Catholic influence, right? It really doesn't make sense. And you need Christian teaching to understand the history of America and Europe and Western civilization, and also to provide that moral framework that's carried us through from when people formed the founding and through to today. So I think that's a great point you made. And moving on to our next case. So unfortunately, there's more bad news coming out of Massachusetts. I hate to say it. I have close family in Massachusetts. But on top of the Massachusetts governor signing a law that it was an abortion bill that we covered last week pretty much. But now there's more terrible stuff happening there. Massachusetts Supreme Court has held that statues of St. Michael and St. Florian on a public building violate the state constitution. And we covered this case in an episode beforehand, but just to cover it quickly for those who aren't aware, the story starts with the mayor of Quincy, Mayor Thomas Koch. And a fun fact about him is that he's a practicing Catholic who left the Democratic Party in 2018 over its support of abortion rights. So awesome for him. And in 2023, he commissioned two 10-foot bronze statues on the facade of its public safety building. One is of St. Michael the Archangel crushing a demon, which, as the kids would say, is extremely based. And the other depicts St. Florian, who's a patron of firefighters, and he's extinguishing a fire. 15 Quincy residents of a bunch of different faiths sued the city that May, and they're represented by the usual suspects, the ACLU, Massachusetts, Americans United for Separation of Church and State, and the Freedom from Religion Foundation. And their core argument is that displaying the statues in front of a city building would violate the state constitution by promoting one religion over others and religion over non-religion. So then in October 2025, the Norfolk Superior Court denied the city's motion to dismiss and granted a preliminary injunction because the statues had no secular purpose. The trial court also said that to defer the founders' understanding would perpetrate the petty bigotries of the past. So they seem very resistant to the whole history and tradition test that the Supreme Court, the U.S. Supreme Court, has been using. Kind of just in courts in Massachusetts in general, they don't seem to like the history and tradition test. And we'll talk about that later in the case as well. But the city of Quincy got a direct appellate review, and it got to the Massachusetts Supreme Court, and they heard oral arguments. And then just last week, August 20th, the Massachusetts Supreme Court unanimously upheld the preliminary injunction barring the city of Quincy from installing those statues. And the case name is FitzMorris versus City of Quincy, and Justice Scott Kafker, writing for the court majority, it was unanimous actually, not a majority, but he wrote that the display likely violates Article 3 of the Massachusetts Declaration of Rights, which places all religious sects equally under the protection of the law and forbids establishing the subordination of one denomination over another. And I was looking through some of the briefs in this case, and one by Michael McConnell caught my eye. He's a religious liberty scholar, former circuit judge, and I never saw the opinion address this argument that these statues don't involve the protection of law or subordination by law at all, right? That's what the argument apparently is in the Massachusetts Constitution. The plaintiffs are complaining that the mayor decided to install statues that have both secular and religious significance, but they don't allege any specific law that requires them to do so, right? Protection of the law in something like what the Massachusetts Constitution talks about would be something like an ecclesiastical hierarchy or a religious test, not a mayor choosing to use funds to put in statues on a building. That's not the protection of law as in the Massachusetts Constitution. But okay, moving on from the text, a textual argument. What really surprised me reading through this opinion was that the court so heavily and mainly relies on the Lemon test still. And it's the Lemon test as kind of incorporated through a Massachusetts State Supreme Court decision, Colo versus Treasurer and Receiver Gen, which involved a taxpayer challenge to public salaries for the chaplains of Massachusetts House and Senate. And so while I'm reading through this opinion, I'm kind of asking myself, wait, if the Lemon test was dead, how are they using this? And that's kind of exactly what the city argued, actually, that the Massachusetts Supreme Court got the Lemon test from the U.S. Supreme Court, but now in Kennedy versus Bremerton, the U.S. Supreme Court discarded it. So, you'd think it's a basic syllogism, therefore this court should discard it too. But Massachusetts Supreme Court answers that the borrowing of Lemon was more structural rather than just like the black letter doctrine of the Lemon test. So the court specifically says the Colo framework is neither limited to nor dependent upon a mechanistic application of Lemon factors. Importantly, our analysis in Colo began with a careful and nuanced examination of the purposes of history and tradition and both the challenge practices and the relevant constitutional amendments. It also recognized that the text, purpose, and history of Article 3 have evolved over time, reflecting societal changes as well. So they're basically saying Kennedy doesn't get automatically discarded. And despite kind of talking about history in that quoted paragraph I just gave you, they also make the argument kind of against the history and tradition method that the Supreme Court uses. And they quote Obergefell, saying, history and tradition guide and discipline the inquiry, but do not set its outer boundaries. That method respects our history and learns from it without allowing the past alone to rule the present. So, yeah, basically rejecting kind of Kennedy. And a follow-up question I had from this was, well, how can a state court do this? Can they just take a defunct test from the U.S. Supreme Court and just decide to use it anyways? And we have to remember a little lesson from Fed courts class that federal preemption is a floor constitutionally, not a ceiling. So if a state constitution or state law offers fewer rights than the federal standard, the federal rule overrides the state rule. But states can always offer a more stringent protection than what the federal constitution offers. And here the Massachusetts Constitution is more anti-establishment than the federal constitution, which is allowed. And the real ceiling on this, on like a really separationist state constitution, isn't the establishment clause, it's the free exercise clause. And the city does make this kind of argument, a la the kind of Masterpiece Cakeshop. I think they cite Masterpiece Cakeshop directly. But unfortunately, the court closes this off because they reason that the injunction restrains city action, not individual action, because the municipality doesn't receive First Amendment exercise rights at all. And that's true. First Amendment rights are usually given to individuals to be protected from government interference, not the other way around. So then the city's kind of stuck between a rock and a hard place, using Lemon-esque arguments that you see in Supreme Court cases like Lynch versus Donnelly, County of Allegheny versus ACLU, where there the Supreme Court defined a nativity scene as overtly religious, while a Christmas tree is treated as secular. And for some reason, both have to be surrounded by a secular religious symbol. I don't know, you might as well say they have to all be 6 feet apart, like in COVID times too, or that Santa and baby Jesus can't make eye contact with Rudolph, or that's an establishment clause violation. I'm being a little facetious, but it's really just to demonstrate the absurdity and nonsensical nature of the Lemon test that the Massachusetts Supreme Court has decided to use. And so kind of stuck with these Lemon test arguments, the city argues, represented by Becket, that the Michael and Florian statues do have a secular purpose. They're civic emblems of courage and sacrifice within police and fire culture, and they point to the Florian cross being used in fire departments in Massachusetts, and that there's a statue of another religious character, Moses, displayed at another courthouse in Massachusetts. But the court still found that the government funded and placed statues, that these two bronze Catholic statues, they prefer and give special treatment to a certain religion because the statues are large, they're new and not long-standing historic monuments. They stand alone as the building's only kind of adornment, not within a broader collection of other non-religious statues or religious figures. And their iconography is closely related with the Catholic tradition. So, okay, obviously I agree that they're icons of the Catholic tradition. I feel like that's hard to not argue, and it's probably just more of the reality of the situation. And I love the fact that they are. But let's take some of those other considerations, those factors that the Massachusetts Supreme Court talked about, that the statues aren't long-standing historical monuments and they're not surrounded by non-religious statues. The first case that kind of comes to mind, similar analogously, is American Legion versus American Humanist Association. And actually, the Massachusetts Supreme Court cites this case exactly, saying, for nearly a century, the Bladensburg Cross has expressed the community's grief at the loss of the young men who perished. Its thanks for their sacrifice and its dedication to the ideals for which they fought. Here, by contrast, without such secular meaning, built through common history, these new statues have greater potential to be perceived as government endorsement of a particular religion and subordination of other religions in violation of Article 3 of the Massachusetts Constitution. So it seems like kind of what they're saying is the principle from American Legion is, okay, you can have an overtly religious symbol. I can't think of a more religious symbol than the cross, right? And it doesn't necessarily have to be surrounded by a bunch of non-religious other symbols or statues. But the religious symbol just can't be new. The religious symbol has to be old and have accumulated a secular purpose and tradition. Newer religious monuments get less constitutional protection then. And I would just like to kind of like question that or kind of poke at that a little bit and say, is that a principled, sensible approach that we should defend? Or is it an accidental kind of downstream effect of how American Legion was written? And it was just sad to see the Massachusetts Supreme Court taking our most monument-friendly Establishment Clause precedent and using it to defeat the city of Quincy's Catholic statues. So I will see how the rest of it goes. One of the things in the court opinion that the court talks about is that I don't think there was any rebuttal evidence about the secular nature, like expert testimony about the secular nature of these statues. So I'm curious to see if that changes the case at all. But for now, the injunction remains in place and it's proceeding in Norfolk Superior Court.
Yeah, it's an interesting case, and it brings up an important point that you hinted at, right? Because you start with, obviously, the Massachusetts court here seems to be relying on principles from Lemon, which has been overruled. But again, it's important to note that the Massachusetts case here is not deciding the case on Establishment Clause grounds. Like you said, it's deciding it on the Massachusetts equivalent of the Establishment Clause. And so the question of can a state court rely on an overruled federal test? The answer is yes, right? Because we have states on the other side that in the wake of Employment Division versus Smith, there are several states that still say, well, when we interpret the state equivalent of the Free Exercise Clause, we're basically still using the Sherbert standard and we're not using Smith. So yes, state courts are free to do that unless, like you said, the state's interpretation of its own constitution's Establishment Clause then violates the current jurisprudence surrounding the Free Exercise Clause. So it's a tough case. It's obviously an unfortunate example because I don't want to see states that are using their state equivalent of the Establishment Clause to completely exclude religious expression that I think is quite consistent with our history and tradition. That's bad. But it is also a tougher case. And I think you pointed this out. I think the best argument actually here might be an articulation of the discrimination that Massachusetts is essentially engaging in. They're saying, okay, the Saints Michael and Florian are newer, less historical, traditional, secular purpose. That's questionable. But to distinguish and say Bladensburg cross, like the cross, that's well established and that's okay. But these statues of Saint Michael and Saint Florian, that's not okay. that I think we're starting to get into the territory that we've talked about in the past from Wisconsin Catholic Charities, where it's like, hold on. So your line is that you can have religious symbols, but only certain kinds, and we're going to delve into which ones are okay and which ones are. Then it starts to look like you're picking and choosing religious symbols in a way that might actually run afoul of Establishment Clause symbols, right? Why is the cross okay, but St. Michael's not? Um, I don't know. And again, it would be a stronger case for Massachusetts if everyone was very clearly like, nope, St. Michael and St. Florian, these are Catholic symbols and we're going to use these. But if, a Protestant or a Jewish denomination wanted to put up a statue of Moses, the lawgiver at that same police station, we're going to say no to that because we're a pro-Catholic police and fire city. Yeah, then you'd have a problem. But I just don't see any of the stuff that would warrant this distinction. And I think there's a good case to be made that you're picking and choosing which religious symbols, that there's just some anti-Catholicism kind of lurking behind this. All right. And with that, we'll go to our last case, which I'm not going to spend a ton of time on because it's legally fairly simple, but I think it points out an interesting issue. This is a prisoner who had his ritual materials as an alleged Wiccan confiscated by the prison in which he's incarcerated. So this appeal was decided by the Ninth Circuit just last week. It's a case called Goff v. Road. It's an interesting one. So the district court here granted summary judgment for a bunch of prison guards. It's honestly a little bit hard to figure out some of the factual stuff going on of why he had these things confiscated and what's actually going on here. It's a little murky, but basically he had some kind of a medallion and what he's calling an altar cloth, and they were confiscated by the prison and not returned. And so this inmate filed suit on both First Amendment and RLUIPA, it's Religious Land Use and Institutionalized Persons Act grounds. We often talk about RLUIPA on the land use side, but it also does have religious rights protections for prisoners. And so it's worth noting from the outset that the analysis on First Amendment grounds and the analysis on RLUIPA grounds may actually diverge. I will get to that in a minute. But so basically, district court grants summary judgment in favor of the prison guards, says there was no substantial burden on this inmate's religious exercise. And in a 2-1 decision, the Ninth Circuit here reversed and held that the inmate presented sufficient evidence to create a dispute that should go to trial over whether the confiscation of his Wiccan items constitute a substantial burden on his religious exercise. So again, this is not an injunction. This is a summary judgment case where the district court heard all the evidence and said, yeah, there's no dispute of material fact, and there's just no legal way that the prisoner wins. Ninth Circuit reversed. So according to the plaintiff, I'm going to just read from the Ninth Circuit opinion. His medallion stored energy and had significant spiritual value, preventing negative or evil forces, energies that would seek to cause imbalance or harm. And his altar cloth was a consecrated space for casting runes, for divination, altar items, and prayer focus. I'm not up on my Wiccan theology, so I don't actually know what a lot of this means, but it seems like he has an articulation of what these things are for, and that it's part of his Wiccan practice. I think it's interesting that first the illegal analysis, and then I'll comment on a bigger question. The focus of the Ninth Circuit opinion here was whether the confiscation of these items placed a substantial burden on Goff's religious exercise, which would warrant strict scrutiny under Free Exercise Clause or RLUIPA. The majority agree that there are facts that say maybe, and then it's not appropriate to dispose of this at summary judgment. I'm just going to read quickly from the dissent because there are some factual issues, like I said before, that don't really make sense to me from what we have here in the opinion. The dissent, the judge dissenting says, there's absolutely no evidence in the record that Goff was coerced into acting contrary to his beliefs or that he was pressured in any way to modify his behavior and violate his beliefs. Indeed, Goff continued to practice his rituals as he did before confiscation of the altar cloth and medallion. In addition, Goff could have replaced the altar cloth and medallion, but elected not to do so. It's undisputed that the altar cloth and medallion cost $12 each. It's also undisputed that Goff was previously allowed to possess the medallion and chain. There's nothing in the record to suggest that a request to replace this altar cloth and medallion would be denied. Goff does not assert that he lacks the funds to replace them. Rather, he has elected not to do so because he will not place money on his account until he starts getting these lawsuits dealt with and taken care of, end quote. So I don't, again, it's not clear to me what's going on. What if the record says he could have replaced these things, I don't know why they were confiscated in the first place. There's apparently an argument about whether taking these things away is a substantial burden on religious exercise or whether he can carry on and exercise what he was doing without this medallion and cloth. Um, Again, not really clear. But regardless of why the items were confiscated, the majority, I think, makes an interesting legal point that this was probably resolved on the wrong element of the test here, especially under RLUIPA. And the majority says courts consider whether prisoners have an alternative method of engaging in religious practice, which is what the dissent seems to say. You could have done it without these items. In assessing whether prison officials have met their burden and showing that their actions are reasonably related to a legitimate penological interest, which is a ground that the district court did not reach and that defendants have not otherwise advanced in this court. So my point here is that it seems like maybe this was just disposed of in the wrong way by the lower court. I think, right, if the plaintiff argues that he has a religious exercise right that was substantially burdened, in RLUIPA institutionalized persons cases, the prison guards can respond and say that they have a penological legitimate reason to keep these things out, right? If you can use the medallion as a weapon or what have you, even if religious exercise is burdened, they probably prevail in that case. So it seems like the problem is that the district court ruled in favor of the defendants on the wrong grounds. They argued there's no substantial burden on free exercise. They probably would have been on stronger grounds to say, okay, even if substantial burden was in place here, there's a penological interest that comes in later, and that might have disposed of the case in the same way. So this now my final point, and again, we'll watch what happens back at the district court. I'm curious to see if that is the end of it. They say, okay, substantial burden, great, but there's a legitimate interest in confiscating this stuff, and that's the end of the case. I don't know how that'll play out. But I also want to bring up a point that I've done a lot of work on over the years, which is what is a religion? Now, again, I don't know if that would be dispositive to this particular case, but I want to just use this as a springboard and talk about that for just a minute. One thing I'll say is the question of what is a religion definitionally for originalists, textualists, when interpreting the free exercise clause versus interpreting RLUIPA might be quite different because the First Amendment is going to be looking at the definition of religion in the early founding era. RLUIPA was passed in 2000. They may have very different understandings of what a religion is by 2000. But zoning, like, zooming out there, I think the reason we got to like employment division versus Smith, for example, was this exact problem of an ever-growing, morphing definition of religion that encompasses beliefs and practices that are quite foreign to the religious liberty protections intended by the founders of this country. Right? In Smith, you had two men who were were counselors and they were smoking peyote, claiming it was part of their Native American tribal religion. Here we have a convicted murderer suing for his supposed right to essentially practice witchcraft. I think that this is all speculative, but a lot of people kind of thought that the reason Justice Scalia decided that he was going to go with the narrowing of the free exercise clause was, well, I mean, if we're using the free exercise clause to, allow peyote smoking under native tribes, or he probably would have said the same thing here. If we're using free exercise to, allow Wiccans to practice witchcraft in jail, like, let's just narrow the right because this is out of control. And I think that's an interesting and maybe legitimate concern, but the wrong way to deal with it. And this, again, I've done work on this at National Affairs, at the American Conservative, and elsewhere. You can read my work on the definition of religion over the last 3 years or so. But basically, I think James Madison, when talking about the Virginia religious liberty scope, and most of the early sources in the first 100 years of the nation, thought religion was something like the duty we owe to our creator. That's not particularly specific, but I think it's fairly monotheistic, and it's certainly theistic. So I think drawing some line between what is a religion and what is not a religion is necessary, and that's not where we are today. We have these amorphous tests, which include religious liberty protections for explicitly non-theistic belief systems, right? We've got like several conscientious objector cases that came up in the like early to mid 20th century, especially around Vietnam, where people were explicitly atheists or agnostics, but they still got religious rights to object to being in war. And I think it's just, those might be laudable belief systems, but I think definitionally they're just not religions. And that's a problem. It's hard to interpret what is a religious right if we don't know what a religion is. That should be fairly uncontroversial. And I think when we're bending and twisting that word to mean what it clearly didn't mean when we had these protections established by law, we're in a problematic place. So in this specific situation, I don't know how Wicca would fall. I don't know a ton about the Wiccan belief system. I do know from a little bit of research, it's not monotheistic. It seems to be polytheistic, or at least bitheistic. There's like a nature goddess and some kind of male god or something. It's mostly like a nature religion, certainly not monotheistic. But I certainly don't think that the founders thought that they were creating a constitutional right to own like pagan artifacts and cast spells from a prison when they were enacting the First Amendment. Now, again, RLUIPA was passed in 2000. So by then, legislators may very well have intended that these kind of non-traditional belief systems and practices would be included in the definition of religious exercise. I don't know. But in any event, I just wish this was something that would get more attention. So I keep hammering at this. You can't coherently protect a right if it isn't clear what the definition or scope of that right is. We need to know what a religion is in order to know what the free exercise of religion is.
Yeah, to work off that, Frank, this is actually an issue that came up in the McCutcheon versus Nicholson case, recently argued by Becket, I think just a few months ago. And they also draw, maybe hopefully reading your article in National Affairs first, but they also draw on that definition of religion by James Madison. And it's most likely a monotheistic definition. And while that's difficult for in some cases, I think it's not necessarily sectarian, and it's not an arbitrary distinction either. It's really a truth that's open to all people. It's very inclusive, actually, because it rests on natural theology, which is, well, and just indulge me for a little bit about like the theological, philosophical kind of foundation of it. But natural theology is the knowledge of God's existence and nature that's attainable through reason alone. You don't need divine revelation from Christian, Jewish, whatever sources, right? It's the same philosophical reasoning that Aristotle used when he posits an unmoved mover as the necessary first cause of the universe that leads directly to a theistic God, right? One that's absolute, unconditioned, who's the source of all existence, maybe is all-knowing, all-powerful, all these kinds of things. These are the same arguments that are accessible to a pagan philosopher like Plato or Aristotle that are accessible to St. Thomas. And a lot of those arguments are gone through in Aquinas' 5 ways. So this kind of tradition of like natural law, natural theology, it's also steeped in American founding, the history of the American founding. From Roman jurists through St. Thomas and William Blackstone, it's in the very structure of American common law. A lot of scholars like Justin Dyer and others have demonstrated that many of the founders were steeped in natural law, natural theology. Professor Brad Berzer talks about how natural law influenced Thomas Jefferson, maybe through Suarez or Bellarmine or some of those people, eventually made its way to Thomas Jefferson, made its way into the Declaration of Independence and the laws of nature and nature's God, right? Those ideas might have come from natural law Catholic thinkers even. And even in the debates of the Constitution, Bill of Rights, the 3 thinkers most frequently cited are Montesquieu, Blackstone, and John Adams. These are the very frequently cited, maybe top 5. And they're all proponents of natural law, right? Adams kind of encapsulated this essence when he said, these are the revolutionary principles. They are the principles of Aristotle and Plato, of Livy and Cicero, Sidney, Harrington, and Locke, the principles of nature and eternal reason. I certainly don't think that sentence encapsulates people with Harry Potter wands running around in the forest doing whatever. So I think that's a monotheistic definition, and that's probably much closer to the definition of religion at the founding area than whatever is going on with Wiccan witches.
Yeah, I think that's right. And it's a good point. And it's worth stating that this need not be a division between natural or classical law theorists and originalists on this question, because I think you're right that the the classical and natural law tradition of what a religion is and why it's being protected in the Bill of Rights is quite consistent with those classical traditions. I think the classical traditions are baked right in, right? We're talking about nature and nature's God, right? Which, like you said, does not get you to um, Catholicism only, but it definitely, I think, gets you to the monotheistic, right? The unmoved mover, the one God who rules the universe. And that's what religion is in reference to, not any belief system that a person happens to have or concoct. So I think that's right. Whether you're a natural law theorist or whether you're an originalist, that you should come to the same conclusion that we've gone way far afield in expanding what a religion is under any coherent legal definition in this country.
Yes, and one liner I'd like to leave everyone with is if anything's a religion, then nothing's a religion. So we have
Yeah.
to define it in order for the right to actually mean anything.
Yep. Absolutely right. All right. And that's a good note to wrap up on. So I think with that, we'll just thank you all for listening, and we hope you'll join us next week as we continue to highlight and discuss the most important ongoing legal issues that affect religious liberty and the work of faith-based nonprofit organizations. We'll talk to you next week. Thanks for joining us, and God bless you all.